On June 13, 1994, Mervyn Smith, an expert in fingerprint and palm print identification, serving 33 years in the field of forensic fingerprint identification with the FBI, and certified as a latent print expert by the National Chapter of the Latent Print Certification Board of International Association for Identification, and by the Federal Bureau of Investigation, was contacted by counsel for Carlton Gary. He was asked to conduct examination of the fingerprint evidence for this case. Mervyn Smith indicates in his affidavit that he was provided with photostatic copies of Carlton's prints and those lifted from the crime scenes, and they were of poor quality. He was not given access to the original prints or a high-quality reproduction. The attorney for Carlton Gary, Jeffrey Ertel, informed him that the original trial exhibits cannot be located. In an order from habeas hearing requested by Carlton Gary and his counsel, which was granted by the Honorable Daniel Coursey on March 26, 1994 in Butts County, Georgia, all evidence was to be permitted for examination. However, on May 27, 1994, the same counsel for Carlton Gary indicates, counsel contacted District Attorney Douglas Pullen, who informed counsel that the physical evidence was entered into evidence and became part of the trial record as State's Exhibit. However, in a disposition as of November 21, 1995, Judge Bill Smith, who was the former DA at the original trial of Carlton Gary, stated although the exhibits were in the state's file at the time of trial, he did not turn them over to the defense because he did not believe they were exculpatory, which would be used to exclude Carlton as a suspect. This is not only a violation of Brady v. Maryland, which requires all evidence being withheld by government that is material to determining a criminal defendant's punishment or guilt, is a violation of that defendant's constitutional right to due process. But it is also a direct violation of Judge Daniel Coursey's order on March 26, 1994, some 3 months prior. To say in his affidavit that Mervyn Smith was told these exhibits could not be located is a direct lie and an attempt to obstruct justice. Stay tuned for the next part in this series.